The Electoral Court has dismissed Jabulani Khumalo's urgent bid to be reinstated as Umkhonto weSizwe party leader. He had argued that his removal was unlawful, citing undue process followed by party officials. The court described his application as contradictory and an abuse of its processes and resources. Joining us is Kevin Smith, who's a legal expert, to talk about this breaking news. Kevin, thank you so much for joining us in studio.
Thank you for having me.
What does this dismissal of Jabulani Khumalo's court bid mean? Does this mean that officially now his relationship with the MK party is over?
Well, it means a couple of things. One of which is that the court has confirmed that he is currently not a member of the MK party, and he will also not serve as its leader or its president. So his relationship in that regard has been terminated. However, interestingly enough, as you look at the judgment and his court papers themselves, he doesn't necessarily make out a case for the procedure followed for his expulsion and if that decision can be either reviewed or reversed. So whether any internal procedures are then followed hereafter are yet to be seen. But as it stands, it's been confirmed that he's no longer a member of the MK party. He's not their leader and he's not their president.
So that gives us an answer come Friday, because there was a lot of confusion as to, the MK party members saying, senior leadership saying they will not go to that first sitting. And then you also had Jabulani Khumalo, who was saying, look, I'm the rightful leader of this party. And in fact, I want to be sworn in as a member of parliament. So it answers the direct question of whether he will be at that National Assembly sitting or not. He can't go anymore.
Of course. One of the things that the court has rightly pointed out is the fact that he has asked the court for them to reinstate him, which the court didn't have the authority or the power to do. That is an internal political matter that should be handled between the MK party itself. And given that now he doesn't have any locus standi for this case, he also doesn't have any locus standi to be in parliament. So his decision to say that his members will be there on Friday, of course, will fall on deaf ears because the MK party has made it clear that that's not their stance.
Another win for former President Jacob Zuma, right?
Of course. I mean, this is actually a matter that Mr. Khumalo has prejudiced himself in how his papers were drafted and formed. One of the reasons why his application actually failed is that it lacked urgency. It should have been brought within 3 days of the decision having been made. And it was in fact brought about 16 days thereafter. And his court papers do not set out a case or give any justification as to why the delay took place. So the court couldn't even see this matter on urgency, and he failed the test of urgency. And that is something where in these matters it actually becomes an issue where had he had the right merits in place but couldn't justify urgency, he would have lost in any event. So on multiple grounds, his case was defective.
So the claims that he made as well in those court papers to say, look, not only were these letters written without my consent, but my signature was forged, and all the claims that he had made as well, which were quite serious allegations, do those all go out the window?
As it relates to this matter, they do go out the window. One of the important factors that we need to consider in this matter as well is that the MK party has its own constitution. And within that constitution, it has a mechanism as to how its leadership structure and its executive membership will be elected. And according to the court, that is yet to be taken place. So neither Mr. Khumalo or Mr. Zuma have been formally elected in those roles, nor has a formal executive membership body been established by the MK party. So his claims in that regard stem from the fact that he insists that he is not only their leader, but their president. But the court has confirmed that their own internal procedures in that regard are yet to be followed. So even on those grounds, it can't sustain itself.
So even on the grounds that he was the one who actually initially registered the party as well, he still would have had a losing case. Is that what I'm hearing you say?
Yes, because at the end of the day, the MK party's constitution says that they will have a formal electoral process where they will elect their president, their formal leadership, and the executive body. That is set out in their constitution. They can't move away from their own constitution. Whether he is their leader or the founding member, he is still bound by that constitution himself. And as the court rightfully points out, that until that process has been followed, he cannot make claim to that position, nor can Mr. Zuma do so.
So let's say then the party does formulate their constitution, they do then elect their leaders, and it's all done constitutionally. So can then, in say 3 months from now, Mr. Jabulani Khumalo then go back and try and fight this matter again legally?
That would be a factual matter that I don't think can take place, because the IEC itself, when Mr. Khumalo said that they had acted ultra vires, meaning outside of their power, by removing him and making a decision in that regard, they actually only made a recordal of what was communicated to them in writing, which, according to its own regulations, that stands the test that the IEC required at that time. They needed,
even if that form of in writing, and sorry to cut you off there,
no
Kevin,
problem.
but even if their form of in writing is an unlawful letter, they can accept that.
Remember
or
that
an allegedly unlawful one.
Allegedly, yes. Remember that the MK party had to follow their own internal procedures in order to show that that letter was from the party or was not from the party. And in the responding case by Mr. Zuma and the other respondents, they did say that that issue was communicated in person to himself and various other witnesses, which they then took to the IEC and they communicated that to them in writing. So if you think about the sequence of events there, is that they are only confirming to the IEC what the internal decision already was. So the IEC does not have any influence over that. So him insisting that the IEC has to reverse that decision and then reinstate him, they don't have the power to do so, because again, all they're doing is recording what the party itself is communicating to them. So if in future he is then reinstated, that reinstatement process has to be internal, which is the same thing that the court has said in its judgment, is that for him to contest his reinstatement or him to contest his expulsion, he needs to bring a basis upon which that is done. Either it's going to go to the MK's constitution to show that it was a procedurally unfair step, or it has to be in the form that an internal decision is then made that they then can record further. But he cannot, as his own, as the own applicant here and as his own litigant, force the court or force the IEC to do so, because there are internal procedures that still have to be followed.
I mean, to your point as well, Advocate Mitchell de Beer for the IEC raised that point in particular to say the Commission did not have the power to replace or remove a political party leader. So this fight, should he had rather have taken it internally to the MK and try and reason with him to get him to be the party leader, which, I mean, let's be realistic here. I don't think that would have gone down, because they already have their charismatic leader that also garnered much of the support that that they got, that we saw them taking that third place in national government. So this is not a legal battle, you say. This is actually a political fight that he should have fought internally in his party and left the courts alone. Yes,
of course. I mean, at the end of the day, political party is what you would call a voluntary association. And how you join that party is through its constitution, which forms a contractual relationship between you and the party and the members of that party, right? So any of these internal issues, the mechanism for them to be resolved should be and are in fact in the MK party's constitution. So whether his expulsion was done wrongfully, the way for him to find his redress would have been, as a first instance, to engage the MK party's constitution. Then if it is found that the further executive membership, including Mr. Zuma, are then in breach of their own constitution or are not following the provisions of their own constitution, that then gives him a legal basis to challenge those decisions. But what he is in fact doing here is that he's compelling the court to make those decisions without the court having sufficient legal context in the form of internal procedures having been exhausted and the court being approached as a matter of last resort. Because we must understand whether this is an urgent court application or not, the court has to be engaged as a matter of last resort. And in this instance, it seems as though the court was engaged as a matter of first resort. And that is also where the defect in his case lies. Well, thank you so much for sharing your insights with us and helping us understand this a little bit more and joining us in studio, Kevin. Thank you for having me. That was Kevin Smith, who's a legal expert, just talking to us about that judgment that's come through Jabulani Khumalo losing his bid to be reinstated as the Umkhonto we Sizwe party leader.